As seat sharing talks in the India alliance finally take off, there are all kinds of other ideological contradictions that are surfacing. This, even as the Shiv Sena Uddhav Thackeray group awaits a critical decision on the disqualification issue of its MLAs. The speaker is to take that decision. Now, remember, both the Eknath Shinde Shiv Sena and the Uddhav Thackeray Shiv Sena have made a case for the disqualification of each other's MLAs. The Uddhav Thackeray Shiv Sena has also gone to the Supreme Court, arguing that a recent meeting between the Maharashtra Speaker and Eknath Shinde creates a conflict of interest, and therefore they have questioned the speaker's neutrality. That decision is expected perhaps even in the next few moments, and we'll keep a close eye on that story. But to talk also about what's going on within the India alliance, how seat sharing conversations are progressing, and the multiple ideological questions, some would say contradictions and cracks that are arising, let's join our newsmaker today. Priyanka Chaturvedi, leader of the Shiv Sena, the Uddhav Thackeray group, joins us now. Priyanka, that decision of the disqualification issue from the speaker should have been in with us by now. Maybe it will still come. What are you expecting?
If I go as per my country's constitution and go by the Schedule 10 of India's constitution, the Supreme Court has been very clear while hearing this case that Schedule 10 is supreme. And Schedule 10 says clearly that the political party leader decides who the chief whip is, as well as who the floor leader is. And what the Shinde faction did was in direct conflict with what Schedule 10 stipulates. So what they did was unconstitutional, be illegal. However, the decision of disqualification was left on the speaker. So it's a very open and shut case if you go by it. The speaker has to act like a tribunal judge, and he has to be fair and unbiased in his decision. And decision should be going with what the constitution says, which is disqualification of Eknath Shinde faction and all the MLAs who chose to go against the party leadership, which was Uddhav Balasaheb Thackeray. So if I read my constitution clearly, I go by the belief that constitution will prevail and not Modi Shah's idea of how democracy functions.
And yet your party has already sort of petitioned the Supreme Court, which suggests to me that you are expecting an adverse verdict. And you have suggested that a very meeting between the speaker and Mr. Shinde creates doubts in your mind.
You know, I'll say one thing. There was a time, there's this very famous saying which goes, "Wahi hota hai jo manzoor khuda hota hai." But times have changed. Now the situation is, "Wahi hota hai jo Modi Shah ka man hota hai." So we have to also understand, like I said in my opening comments, that the speaker was in the position of a tribunal judge. He becomes free, fair, unbiased, and he has to give his opinion. And he has to hear both sides in a fair manner. With him going to the chief minister's office. Now, this is a chief minister who himself stands to be disqualified because he's part of the first 16 list that we had gone and has already, by the Supreme Court, called an unconstitutional illegal decision. So going by that, he's going and meeting the chief minister at a time when he's also hearing the case on in his chambers with regards to the disqualification procedure. I think it's incorrect and goes against the spirit of the Supreme Court judgment. So I think it is our duty that we make the Supreme Court aware that while you have given the responsibility to the chair, the chair doesn't seem to be understanding the entire responsibility given to him, because this decision will not just impact my state, it will impact the politics of this country. So I think it's just that we want the Supreme Court to be aware that the verdict has to be in the spirit of what the 10th schedule says.
So let's see if the verdict comes while we're still talking to you. But in the meantime, seat sharing talks are finally on. We were talking to Sanjay Raut a few days ago on our platform, and he expressed a little bit of disappointment at the pace of response from the Congress. He said Congress ne thodi der kar di, Congress ko thodi urgency dikhani chahiye. That's one point he made. The other statement he made that annoyed some of the Maharashtra Congress leaders was that the Congress has to start from point zero. Congress leaders privately saying how can a leader who doesn't have a party talk like this? How would you respond to Mr. Raut's comments, and what can you tell us about seat sharing agreements thus far in Maharashtra?
Okay, so as far as Maharashtra is concerned, what Congress needs to understand is that Shiv Sena, even after a split, is a cadre-based party. The cadre stands firmly with Uddhav Balasaheb Thackeray. So whoever is the candidate that he chooses is in a position of victory simply because the cadre will help get him to win. And we are, all our cadre is waiting for the elections to come to teach Eknath Shinde, Narendra Modi, Amit Shah, Devendra Fadnavis a lesson that they perhaps haven't learned across the nation but will learn in the state of Maharashtra because of what they have done in terms of coming to power. Secondly, if you look at the 2019 election outcomes, Shiv Sena was a party in the new alliance. If you look at it, when it was with the BJP, we contest on 23 seats. We won 18. Out of 18, the rest of the seats were very close contests. So we are in a position of strength, and Congress needs to realize that we have to fight from the position of strength, not from a position of trying to regain lost ground, which Congress will do. Now, how many MPs does Congress have? Congress started with one MP in 2019. Unfortunately, he passed away. We still don't have an MP there. So Congress at this point in time has zero MPs. Even after us, we have around 6 MPs. Now coming to NCP. NCP has 4 MPs in the parliament in 2019. So on the basis of what we saw in 2019, it is only fair that we say that we start with 23 seats because we're in the position of winning. And Congress and all our alliance does understand the fact that we will need to contest from a position of strength, not a position of regaining lost ground. So that is
You say that you're in a position of strength, and the Congress needs to understand that. The Congress says that you have lost control over your party. You may have a cadre, but you don't have a party, and so therefore you can't call the shots. You would say what?
No, again, I would repeat, Shiv Sena very much is a party, and the decision of the party is still pending in the Supreme Court. So I will not want to do that. But Shiv Sena, Uddhav Thackeray, and the name itself is enough, and his leadership and the exemplary leadership that he showed during COVID, taking NCP and Congress along, in itself speaks about his popularity in the state of Maharashtra. I think no party can be blind to the fact of what Uddhav Thackeray's popularity rankings are. Whether you look at every single poll that was carried out while he was the chief minister, while he's not the chief minister, he continues to gain popularity. So again, I would reiterate the same thing. While Congress may want to expand its base, but as of now, the reality is totally different from what they're seeking, and that is why it becomes important that we discuss, have a dialogue, and we make a decision. And we are reaching towards that goal because everybody is speaking from an open point of view, not from a closed perspective that this is only how it will be done.
K.C. Tyagi, JDU leader, on this program just yesterday, he said the India alliance is running out of time. He also said that the Congress did not consult its allies before announcing Rahul Gandhi's Bharat Jodo Yatra. This could have been an India alliance yatra. The yatra is meant to start in Manipur and culminate in Maharashtra. Do you share that sentiment? Do you think the Congress should have tried to make this yatra a yatra of the opposition, a united opposition, than the yatra of the Congress party? Today, we're also hearing reports of separate manifestos, not an alliance manifesto.
No, so firstly, I don't know what you're hearing with regards to the manifesto, but what I can say is one thing. Congress party is well within its rights to try and, gain the trust of the people. And it is not duty bound, just like Shiv Sena will continue its rallies, it will continue doing its own thing without being duty bound to take everyone along. Every political party will have their space to do what they have to do. With regards to Bharat Jodo Nyaya Yatra, and when the first phase had happened of Bharat Jodo Yatra, lots of alliance partners had joined in. I was part of the Bharat Jodo Yatra. Sanjay Rautji was part of the Bharat Jodo Yatra. NCP was part of the Bharat Jodo Yatra. Lots of alliance partners are part of the Bharat Jodo Yatra. So anything that helps the India alliance is more than welcome. Now the second part of the question, that they have delayed this decision making. While I do agree that it could have been done, but during the elections, before the assembly elections took place, because we had set the momentum, there was positive sentiment as well. It could have happened. Unfortunately, it did not turn out that way. But again, there's no time lost. We still don't know how many seats BJP will contest on and how many the 43 alliance members will contest on. Nobody is questioning the BJP about that. But there's so many questions, tons of questions coming for our alliance, simply because there are just so many options that we are throwing forward in terms of leadership, in terms of capability, in terms of how do we see India moving forward. While in the Bharatiya Janata Party, all the alliance partners have surrendered to the might of Modi and Amit Shah.
Sorry, I didn't mean to interrupt you, but I think Mr. Narwekar is announcing his decision. I'm just going to increase the sound on that, and then we can get an immediate response from you. Yeah, can we hear that, please?
Attitude towards the Honorable Supreme Court of India, which has provided an extremely guiding force by way of its order, whereby they have given a direction to the whole adjudication of the issues being decided in the proceedings today. Therefore, I would at the outset express my gratitude towards the apex court. At the same time, I would like to express acknowledgement and a big thank you to the staff of the state legislature who have assisted me and the paralegal assistance which I have received from them during the course of the conduct of these proceedings pertaining to disqualification. I would also like to appreciate the cooperation which I have got from counsels appearing on both the sides, and I shall now proceed with the pronouncement of the order. As we are aware that there are certain preliminary issues which are applicable to all the 5 groups out of the 6 groups, and therefore I shall first commence with my ruling on the preliminary issues which concern all the 5 groups. Thereafter, I shall pronounce the operative part of the orders concerning each group and the relevant and important paragraphs pertaining to each group. So we shall commence with group number 1. Preliminary issues. The Honorable Supreme Court in Subhash Desai Supra versus the Governor of Maharashtra, hereinafter referred to as Subhash Desai, was pleased to direct that the Speaker should prima facie determine who the real political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly shall recognize the whip and the leader who were duly authorized by the Shiv Sena political party, keeping with the principles discussed in the said judgment. Hence, keeping in view the factual matrix and the directions of the Honorable Supreme Court, I will prima facie determine who the political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly recognize the whip and the leader who are duly authorized by Shiv Sena political party. Keeping in mind principles discussed in Subhash Desai Supra, it is necessary to consider and determine the said preliminary issue before examining the merits and deciding whether respondents have incurred disqualification under the 10th schedule of the Constitution of India. Thus, the preliminary issue that arises for my consideration before delving into the merits of disqualification petitions under the 10th schedule is which among the 2 factions was the real Shiv Sena political party, and consequently who was the duly authorized leader and or the whip of Shiv Sena political party for the purpose of deciding the present disqualification petition. The other issue framed for my consideration in this group of disqualification petition is whether the respondents have incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution of India on account of their alleged acts and conduct. Paragraph 84 deals with the principles which have been laid down by the Honorable Supreme Court. I am not going to read out those are a part of my order. I'll come to paragraph number 85 now. Thus, what emerges from the principles laid down by the Honorable Apex Court in that the question of who the real political party is has to be considered and determined after giving due weightage to 1. The Constitution of Shiv Sena, 2. The leadership structure of the party, and 3. The legislative majority if 2 or more factions claim to be real political party. The question of who the real political party is hereinafter referred to as the preliminary issue. Since in these proceedings both I have in the previous paragraphs, I've recorded the submissions made by both the parties. I will come down to my observations and conclusions with regards to the preliminary issues. As stated earlier, the decision of the preliminary issue has to be taken after careful analysis of the constitution of Shiv Sena, the leadership structure of the party, and the legislative party majority. After having heard both sides on the above aspect, I now propose to proceed to record my observations and finding on the preliminary issue. As is evident from the submissions of the parties, there is no consensus on the constitution submitted to the Election Commission of India with consent of both the factions. Likewise, the parties have different point of view on the leadership structure, which has to be taken into consideration. The only aspect which is undisputed is the majority in the legislature party. Hence, to embark upon the finding on the preliminary issue, I will have to decide the relevant constitution which has to be taken into account. 2. The leadership structure which existed before the dispute arose. Further, it will also have to be determined as to when the rival factions emerged. Petitioner's assertion that the constitution of the year 2018 is the relevant constitution which has to be taken into account for the purpose of determining the preliminary issue is based on the submission that 1. The 2018 constitution has to be considered as both the parties have relied upon the 2018 amended constitution and acted thereupon. 2. The Election Commission in its order dated 17/2/2023 in dispute case number 1 of 2022 has held that both the parties were aware of the 2018 amendment, and thus the said constitution of 2018 has to be taken as the constitution which is done with the consent of both the factions, as the said constitution of 2018 was never disputed prior to the initiation of these disqualification petitions, and the same was never challenged. 3. Respondents have themselves admitted and relied on the said constitution of 2018. And 4. The statement of Sri Yogesh Kadam that the filing of 2018 constitution along with the respondent's reply was a mistake done by the lawyers cannot be accepted, as the said statement is an afterthought and done only with the intention to mitigate the damaging statements made by Sri Dilip Lande. To the contrary, respondents have asserted that the constitution of the year 1999 has to be the one which has to be borne in mind, as according to the respondents, the constitution of the year 2018 was never submitted to the ECI. Respondents pointed out to the letter dated 4th April 2018 by way of which the petitioner based their claims of submissions of the said constitution to the ECI. By pointing out to the same, respondents submitted that both the said letters do not mention anything about the purported amendments to the constitution or submission of the same thereof to the ECI. A similar claim was made with respect to the letter dated 27/2/2018 by Shri Uddhav Thackeray in the special leave petition number 3997 of 2022. However, in the said SLP, there was no mention about the existence of any such letter dated 4th April 2018. The word submitted appearing in paragraph 168 of Subhash Desai means submitted before the ECI, as is evident from the further part of the said paragraph, which the petitioner has conveniently ignored. The respondents have further submitted that 2018 constitution has been wrongly annexed as a document. The stand of the respondent on the 2018 constitution has always been that it is unconstitutional and was secretly manufactured by Shri Uddhav Thackeray in cahoots with Mr. Anil Desai. This stand has been specifically taken in the reply filed by Shri Eknath Shinde before the Honorable Supreme Court in SLP number 3997 of 2023, way back on 16/3/2023, much before filing of the replies before the Speaker in August 2023. Further, even the additional replies filed on 25/10/2023 in the present proceedings, the aforesaid petition has been reiterated by the respondents. After having considered the submissions advanced by both the parties on the question as to which is the relevant constitution for the purpose of determination of the preliminary issue, I have come to the following conclusion. A. As per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that, pursuant to the initiation of these disqualifications, the Maharashtra Legislature Secretariat had vide letter dated 7 June 2023 requested the Office of the Election Commission of India to provide a copy of the party constitution stroke memorandum stroke rules and regulations.
Okay, we seem to have lost audio there on Mr. Narwekar's key announcement. We're waiting for that. I don't know what's happened. It seems to be a problem at the. There is back. It's back. It's back.
2023 provided a copy of the Constitution and rules of Shiv Sena as available on the record of Election Commission of India. Further, with respect to amendments, if any, to the said Constitution of the party, the Election Commission requested the Legislature Secretariat to refer to the order dated 17 February 2023 passed by the ECI in dispute case number 1 of 2022. Having perused the same, it has to be noted that the copy of the Constitution of Shiv Sena provided by the ECI does not bear any date or year, but as per the ECI, that which is provided vide the reply is the only Constitution of Shiv Sena available on the record of the ECI. Further, with respect to the amendments, if any, to the said Constitution, the Election Commission, vide its order dated 17 February 2023, has held in paragraph 132 4b that the amended Constitution of 2018 is not on the record of the Commission. Thus, the petitioner's submission that the Constitution of the year 2018 has to be taken into account cannot be accepted, as I am bound to follow the directions of the Honorable Apex Court in Subhash Desai Supra, and accordingly take into account the Constitution which the Election Commission has provided. In my jurisdiction under the 10th schedule of the Constitution of India, I cannot delve into any other factor while deciding which is the relevant constitution. As prima facie, it is evident from the records of the ACI that the 1999 constitution is the one which was submitted to the ECI by the Shiv Sena before rival factions emerged. Further, it is also necessary to mention that the petitioner's submission that the Constitution of the year 2018 was submitted to the ECI by referring to the letter dated 4th April 2018 cannot be accepted. A bare perusal of the said letter dated 4th April 2018, by way of which the petitioner based their claim of submission of the said Constitution to the ECI, does not bear any content which shows that an amended Constitution was submitted to the ECI. The said letter only refers to the election held and the results thereof, and nothing more. Further, on closer examination of the special leave petition filed by Mr. Uddhav Thackeray before the Honorable Supreme Court, challenging the ECI decision SLP number 3997 of 2022, I find that exactly same claim has been made about the letter dated 27/2/2018, and there is no mention about the new letter of 4th April 2018. Accordingly, said letter of 2/7/2018 is on the website of the Election Commission of India. However, there is no document relating to the Constitution annexed to it. Hence, on this ground also, petitioner's submission that the Constitution of the year 2018 has to be taken into account cannot be accepted. Petitioner's submission that submitted before the speaker, petitioner's submission that into inverted submitted before the speaker would mean into inverted annexed by the petitioner and the respondents in their respective petitions and replies thereto cannot be accepted as there is a clear provision under the 1986 rule where the leader has to submit the party constitution. Rule 3, subclause 1, subclause B of 1986 rule mandates that the leader into inverted shall furnish into inverted a copy of the rules and regulations, whether known as such or as constitution or any other name of the political party concerned. Further, Rule 3, subclause 4 contemplates that whenever any change takes place in the information furnished by the leader of the legislature party under Rule 3, subclause 1, he shall, as soon as may be thereafter, and in any case within 30 days from the date on which such change has taken place, or written such further period, or within such further period as the speaker may, for sufficient cause allow, furnish in writing information to the speaker with respect to such change. Thus, the submission of constitution before the speaker has to mean submission under Rule 3 of 1986 rules. However, till date, Shiv Sena has not submitted any constitution on the record of the speakers of the speaker under the said Rule 3.
I think Mr. Narwekar is going to take a long time to get through the technicalities, but the direction of where his judgment is headed is quite evident. Priyanka, he's made the point that the petitioner's submissions on a number of counts cannot be accepted. The 2018 constitution and the argument that your section of the Shiv Sena has made cannot be accepted. I think you can make a clear guesstimate about where the eventual verdict is going. Any quick thoughts?
No, the only thing I'd like to say, and with all due respect to the Election Commission of India, if 2018 documents were not withdrawn, how is it that all our AB forms were signed by our party leader, Shri Uddhav Thackeray, and that was given credence? It is such a crying shame that today we are being told that 2018 records cannot be found. So if going by that logic, since 1999 and whatever changes happened post Balasaheb Thackerayji's death and the appointment of Shri Uddhav Thackeray as the party leader, he's signing on all the AB forms. He also mandating Shri Anil Desai to sign on his behalf was all accepted by the Election Commission. But today, it's because there's a disqualification procedure, because Election Commission has, I'm sorry to say this, I'm not going to be pointing a finger at Election Commission, but there are some verdicts that bound to be asked and some questions that need to be asked. Right from deciding who the original Shiv Sena belongs to. It's like तुम्हारे घर में डाका पड़ जाए और जो डाका पड़ा है सामान लेकर जाए चोरी हो जाए, that person जिसने चोरी की है is the one who actually owns the goods. It's such an unfortunate scene. You did not go as per the cadre strength. You did not go as per the national office bearer strength. You did not go as per the official members who continue to be with Uddhav ji. You just went on the legislative assembly and legislative parliamentary party strength. And I think that goes against the basics of what is mandated. That's one. Part two, about this constitution with saying that there is no record. If there was no record, how did it approve of all the AB forms, including which Eknath Shinde has contested upon, including which Dr. Eknath Shinde has contested upon, including all those 40 MLAs who have contested on, has been held legal? They're challenging the authority of Uddhav Balasaheb Thackeray by saying that 2018, constitution is not valid or it has not been found. So I think that is extremely unfortunate. And this heading towards the Supreme Court again.
It is clearly heading towards the Supreme Court, but he's also, Mr. Narwekar, the Speaker, is quoting the Election Commission and saying the Election Commission also recognizes the Shinde faction as the real Shiv Sena. So what do you say on that?
That is exactly what I'm saying. Election Commission is mandated to look at the party strength, not just on the basis of legislative party and legislative parliamentary party. It is supposed to look at the cadre strength. It is supposed to look at office bearer strength. We had submitted affidavit in lakhs. It was over 230,000 affidavits that we had submitted from our side. What they had submitted was in thousands. Now, including the office bearers, the national executive members, we all have that in majority as compared to Shiv Sena faction, which is with the Eknath Shinde group. Honestly, like I started initially, वही होता है जो मंजूर खुदा होता है, वही होता है जो मंजूर कॉन्स्टिट्यूशन होता है. वी आर लिविंग इन अ न्यू एज रियलिटी, which is वही होता है जो मोदी शाह का मानना होता है. And that is what I think the country is suffering from. And if this particular decision, if the decision is taken the way the sentiment is flowing right now by the speaker, will go against constitutional morality and against the spirit of the Supreme Court judgment, which had initially itself said that what they did by appointing the chief whip, by appointing the floor leader, was incorrect and unconstitutional.
How disappointed are you today?
I'm not disappointed.
It's a big setback for your party or for your faction of the Shiv Sena.
No, I'm not disappointed. It was going in the direction of what we thought will happen. Like I said, Manzoor Modi Shah hota hai. Either you be in power or you steal power, or you undermine all mandates of the constitution to come to power. That is what has happened. This only makes our resolve stronger, that we have to fight for India's constitution. We have to fight for India's democracy. And the bugle of change will begin from Maharashtra. We are motivated. We are, I would say, we are inspired to continue fighting for the constitution after this absolutely random judgment which is going against the spirit of the Supreme Court judgment.
All right, absolutely random response decision by the speaker. He's still speaking. There'll be many more details you'll have to respond to, but your first responses are that you think it's a crying shame that documents of 2018 cannot be found. You're questioning how elections took place, how election documentation was accepted, including that of Eknath Shinde, and you are blaming directly the BJP and the Prime Minister and the Home Minister.
Absolutely.
Will here, while Mr. Narwekar is still delivering the rest of his verdict. Priyanka, we'll circle back to you when we have more details from him. Thank you for those initial responses. Thank you.
Thank you.
Bye-bye.
Mojo's story has always made a commitment to its viewers to go to where the story is. And as you can see here, we are at the epicenter of the Israel war on Gaza. We are right at the front line, about 1 mile from the Gaza Strip, as the Israeli military gets ready with its tanks and its gunners to begin its final frontal assault that will take troops into Gaza. As we said, we are not like other organizations. We believe in giving you all sides of the story objectively and as much as possible from the ground. And that's exactly what we're doing here, covering the biggest global story today from the epicenter of the war zone. So please, we need your support. Support us, become a Mojo member, subscribe to us, spread the word, and thank you for your support.